Good morning. We're going to be starting shortly. Give a little time for people to sign in. I think we're ready to start. Okay, good afternoon, and thank you for joining us today. I'd like to welcome you to the FortneyScott webinar, Understanding the Impact of the New SCOTUS Rulings on Workplace Regulations. This webinar will be recorded. All listeners' phones are muted. At any point during this presentation, please feel free to submit a question in the Q&A box, and we will try to answer all of your questions. Today's presenters are FortneyScott attorneys David Fortney, Burt Fishman, and Nita Beecher. And I will now turn the program over to Nita Beecher to start.
Hi, everyone. We're very excited to be here on this very important day to talk about a lot of cases Supreme Court came down with within the last couple of weeks. As Valerie already pointed out, I'm joined by David Fortney and Burt Fishman, and together we'll work through this. Valerie, as you all know, we are the FortneyScott firm. We are a women-owned law firm, and our focus, one of the issues of the day, is on federal administrative agencies, workplace enforcement agencies. And so we are very focused on these cases. The next slide, please. Obviously, if you're our client, this one is not for you, but if you're not our client, this is not intended to be legal advice. All right, so let's jump right in on the agenda. Okay, so the big question of the day is, do these three cases that we're going to discuss today, Loper Bright, Jerkasy, and Corner Post, represent the beginning of the end of the administrative state? And we're going to talk about the cases and what that means. And what is the impact of these cases on the workplace enforcement agencies that we all work with on a daily basis? And finally, to the extent that we know or think, what should employers do about this? Because there are some openings now that we did not have before. Next slide. And with that, I'm going to kick it off and hand it over to David Fortney to give us a little entrance into these cases. David?
Thanks, Nita, and welcome everyone. So I don't think it's hyperbole to just think for a moment that these three decisions that Nita has referenced, with Loper Bright being, of course, the kind of the core, the hub, if you will, represent the most fundamental change in the law with respect to regulations and judicial deference to the administrative agencies when reviewing regulations. In the history of every single person whose compliance programs have been geared towards regulatory efforts, this marks a sea change unlike anything we've seen in our careers. And we go back the entire so-called administrative state, which really started with the New Deal, and with many of the workplace regulations being kind of cornerstones of that. National Labor Relations Act, the Fair Labor Standards Act, and then, of course, many of the laws enacted in the 60s going forward, many of the civil rights laws and so forth. All of those have regulations and sub-regulatory guidance, and the courts have adopted for the last 40 years under Chevron a high degree of deference to the agencies based on their special expertise and in recognition of the role that everyone had understood up to this point Congress wanted the agencies to play. This realignment has really kind of turned most of that on its head, and understanding the practical implications, I think, are so critical to how corporate America and employers now move forward in charting their compliance path. So Burt, let's start with Loper Bright. As I said, I think that is the cornerstone of this new framework that we need to understand and are going to look at.
Yeah, thank you, David, and thank everyone for joining us. It's quite a challenge to try to express the breadth and importance of the Loper Bright ruling. In a 6-3 decision written by the Chief Justice Roberts, as the slide tells us, it overturned a 40-year precedent, which asked judges, and more or less required judges, to defer to the agencies when a statute is either open-ended or ambiguous or invites some kind of interpretation, if the agency, of course, is not arbitrary, not capricious, and is otherwise reasonable. As our society has become more complicated, think of things like the various in environmental laws about what constitutes a carcinogen. Think of all the complicated issues that scientific issues that we normally relied on. Those have been put aside. The new decision held that Chevron deference improperly transferred power to interpret laws from the judges to the federal agencies. And I'll quote Justice Roberts, it's quite interesting. Courts must exercise independent judgment in deciding whether an agency has acted within its statutory authority as the law requires. Courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. The issue remaining, and the court has tried to make this clear, is that they're not questioning the underlying science, although it's hard to tell in some of these rulings. They're really questioning whether Congress properly delegated the authority to the agency to act as they have. And that is a very close call. And already the court has made it clear that they want Chevron dead. In their last act, the court remanded a number of cases, 5 particularly, which had been decided by the lower courts using Chevron deference. Those have been sent back to the court for re-examination, and we anticipate that the courts under the Loper Bright standard will find a reason either to return the regulation to the agency or simply enjoin it. All I can say, and I'll end with this, the court's decision significantly curtails the power of federal agencies to regulate thousands of private companies, products, industries, the environment, and the workplace. And as it runs out, we will see that this is, if you remember a day in our government, this changes how we will be governed.
So let's just look briefly at the next slide on this, because I think that this is a 6-3 decision, and the split is such, but I think that I mean, we quote the relevant language there, the chief, but the dissent led by Justice Kagan, I thought that her characterization was interesting, hubris squared. And her point is one of, where does this court get off substituting its judgment for that of the agencies who have subject matter expertise, et cetera? And her view was that this is just a massive unjustified shift of the court simply deciding whether it's under the major question doctrine of whether a change is authorized or whether the regulation is proper or not. It's the classic, I'll call it the Monday morning quarterbacking, and with the courts more often than not saying simply not good enough when agencies promulgate regulations.
Well, and this opens the door also to because this does not go to the non-delegation and the major question doctrine. So not only do the courts make their own independent decision, and in fact, they just did so in one of the Title IX cases, basically saying there are only 2 sexes. So, protecting gender identity and sexual orientation was never intended to be covered by Congress, despite Bostock.
One of the ramifications of this ruling And it really goes, Nita, to what you were discussing, and that is the very fine point between whether the judges are interpreting the law or in fact writing policy. And from some of the cases that we've been reviewing over the past few years, coming from the circuit courts, and even now from the Supreme Court, the argument can be made that the court has shifted from being a judicial body to being a kind of policy-making body without any limitations, since nobody ever elected a federal judge, and they are accountable to no one. And it's a question for a democracy that we have to deal with.
I will say, just a personal experience point, at one point, as was Burt, I was in a policy-related role at the Labor Department. I was part of a team that would decide under statutes what we were allowed to do or not do as a regulator, what was authorized. And we fully recognized then, because Chevron was fully alive and well, that if there was some doubt, if we could justify it based on our agency expertise, et cetera, that the courts would defer to that. And it did give the regulator a leg up. And what happened, I believe, is that Congress began to recognize, look, the agencies have expertise. We'll generally direct them. Here's the broad, very broad outline, and you now use your expertise, promulgate regulations to implement these broad statements that are included in the statute. With this fundamental change that Loper Bright has, although Congress hasn't amended a single statute, all of those general authorizations may not be sufficient to support and justify very detailed regulatory schemes for workplace and for other matters. And that is, I think, the most fundamental point, and why Loper Bright isn't just a flash in the pan, but it has this ongoing issue, because the courts are going to sort out many, many regulations against a statutory framework that's been in place for a long time under a very different paradigm under which the statute was going to be assessed.
The PWFA, the Pregnant Worker Fairness Act, is a perfect example. There are two places, one in particular, where they talk about related medical conditions. EEOC then interpreted that based on cases. That is likely to be challenged now with Chevron no longer in place.
Sure. And yeah, I mean, and although we now have Loper Bright, I just want to remind folks, a couple of years ago, in the heart of the pandemic, when the OSHA emergency standard was being challenged for vaccination, keep in mind that the OSHA Act does, I should say, authorize vaccinations, but the court in that instance, deploying the major question doctrine, said that the statute wasn't specific. It didn't authorize that type of vaccination, even though the court had previously vetted and approved under the OSHA Act a vaccination dealing with HIV. So some of this feels a little results oriented. It is hard to when you apply a rigorous logical thread to line everything up, and it makes prediction extremely sketchy if you just look at the statute under normal context.
We will probably use this word frequently for the rest of this webinar, but this is one of the cases that begins to create uncertainty for business people, for employers, for employees, for virtually everybody involved in our economic system. And usually you look to the Supreme Court for finality and for certainty. And in this case, and the ones we'll be discussing later, we get exactly the opposite.
I agree.
Nita, tell us about Jerkasy.
So the next slide. So there, of the three cases, this is the second one. This is the SEC, the Securities and Exchange Commission versus Jerkasy. Jerkasy was a former hedge fund manager who was chased up and down by the SEC. And under the Sarbanes-Oxley law, that they found him guilty of fraud and issued him a fine of $1 million, and among other things. In this case, the Chief Justice again wrote the majority opinion 6-3 and held that certain kinds of remedies, in this case, anti-fraud enforcement actions, must be heard by an Article III judge. That means it has to go to federal court. It cannot be held according to in this case, can't go to the ALJs that the SEC has. The Supreme Court took the position that these anti-fraud provisions replicate common law fraud. And so those things which were part of the common law, he's allowed to have a jury, a right to a jury. Otherwise, it violates the Seventh Amendment. There were two other issues. There were three total that the Fifth Circuit decision brought up. The Fifth Circuit also held that the SEC ALJs were unconstitutional because of their double layer of protection. That still stands in the Fifth Circuit. So the whole ALJ framework, SEC and otherwise, is probably at risk in the Fifth Circuit, something else employers have to deal with. Let's look at the next slide. There's a two-part test. So moving forward, the agencies and anyone who's up for enforcement, one, does the claim look like a common law cause of action? And is the remedy legal? So in this case, civil money penalties. David, you can talk a little bit about the child labor laws, for example. If it's a punitive type of penalty, then you're entitled, according to this case, to go into federal court. The court found that although there is a public rights exception, which empowers an agency to handle adjudications, according to the court, it's only for those that do not replicate common law claims. The dissent jumps all over this with both feet, saying this has not been the court's position in the past, and speaking specifically of the OSH Act, which also has punitive measures. And I think, David and Burt, that's a very interesting point that the dissent brings up.
Yeah, there are, of course, the workplace, there are a lot of programs that have ALJ components. I mean, this goes, again, all the way back historically to the Wagner Act and the National Labor Relations Board, but it moves forward. OSHA has an ALJ process, certain Fair Labor Standards Act, child labor and others have that. OFCCP has traditionally relied for 50 years now on an ALJ process to adjudicate claims. And so sorting out what this decision means on each of those claims and what is a common law claim or what is a right that can be properly adjudicated, that is very much up in the air at this point because the court, as the court does, I mean, it issues this one ruling. But I do think that the application, particularly, and I might add that the federal sector workforce, most of their EEO claims go before ALJs at the EEOC also. So there's a lot of ALJ process, and that was really viewed historically as a way of lightening the burden on the courts before we had so much ADR and arbitration and so forth, but these mechanisms would be ways to adjudicate. And there's a lot of whistleblower claims, et cetera, that OSHA handles that also are subject to ALJ proceedings. I think this is going to be very widespread. I'm sorry, Burt. Yeah. Go ahead.
And one of the problems it raises almost immediately is that every adjudication is going to have a mini trial deciding before which forum it should finally be adjudicated. Because take, for example, the OFCCP, most of its remedies are equitable. That is to say, make whole, which means they should be within the public rights, but they start from a contract, from a contract between the government and a contractor, which is the oldest form of common law. So which is it? Is it a common law case that should be adjudicated before a judge and a jury? Or is it an equitable remedy, which is okay to adjudicate in an administrative hearing? And there's more to it than just a choice of forum, because if you have Fifth Amendment due process rights in a court with a judge and a jury, you have many, many more opportunities and many more options for your defense and discovery and in motions, so that this is going to change how cases are not only tried, it's going to change how cases are settled, because agencies are going to have to decide if it's worth pursuing in court or worth finding a way to resolve the case in some other form or in some other way. Combined with Loper Bright, the uncertainty factor is almost impossible to calculate. And that's, we hope, not what judges do.
Burt, you referenced the OFCCP claims. I mean, historically, that's an interesting one. Under Executive Order 11246, for the first 15 years or so of the 11246 Executive Order, those claims were brought by the government against contractors in federal district court, and they were brought as breach of contract claims. That, and there are cases on the books and so forth, but by the end of the Carter administration, that pivoted when they implemented this new ALJ process, and they went forward. So, yeah, I think it's a very, very much a jump ball on that one, and I think that's one where there's likely to be a bit of a flash as these things get sorted out.
Well, there's another piece of that Fifth Circuit decision that the Supreme Court ignored, which was whether or not Congress violated the non-delegation doctrine by allowing the SEC to decide, because the SEC had the option to decide to go into court or to go through the ALJ process. So I think there's so much uncertainty that these cases are creating. It's going to make it a nightmare, not just for employers, but also for the agencies themselves, who are under resourced already.
Correct. Well, let me talk a little bit about the third of the big three cases we're talking about, and that's the Corner Post decision. I always think the facts are kind of interesting. You have a little truck stop up in North Dakota called Corner Post, and Corner Post brings this claim forward challenging the fees that they have to pay when a customer swipes a credit card to get gas or snacks or what have you at the store. The interesting thing is that the regulations that was brought under had previously been challenged. The same challenge had been asserted. The regulations had been found to be properly issued, and cert had been denied by the Supreme Court. Nonetheless, Corner Post came up with an argument saying, wait a minute, even though there's a 6-year statute of limitations, we didn't exist when the regulations were first there. We're a new business, and we weren't in business before. We've just started in business, and now we're impacted by these regulations. So we should be allowed to bring a challenge on those regulations. Well, and Justice Barrett said, you know what, Corner Post, you're right. We agree with you. Again, 6-3 vote, same 3 dissenters. When does the claim accrue? When does the ability to challenge a regulation? Is it, and we typically follow the 6-year limitation period under the Administrative Procedure Act. So when does that, it's a fairly long limitation period. When does the 6 years begin to run? Historically, we had thought it was when the regulation was promulgated, finalized, you had 6 years, file the challenge. Now the court says, no, the claim accrues when the plaintiff is injured by the final agency action. So in this case, Corner Post said we weren't even in existence, so we couldn't have been injured. We brought it within 6 years of our injury. So the dissent, jump on the next slide, please. Of course, at this point, they're just like, this is crazy. When you combine Loper Bright, and now you effectively erase a limitation period, nothing is going to be solid. Any objection to the old rule must be entertained and determined de novo by judges who now apply their own unfettered judgment as to whether the rule should be avoided. That's Justice Jackson, not my words, but those are her words. But the dissent went on and said, look, this is clear at this point. There will be a tsunami of lawsuits against the agencies. Again, the dissent's wording. And that Loper Bright is really ground zero on this, but when you combine it with Corner Post and you combine it with Jerkasy, those 3 suggest a real lack of stability for regulations across the board. And even though the majority sort of poo-pooed that and said, oh, you're kind of overreacting, already in the intervening 10 days, 14 days, we have seen all sorts of new claims filed. We've seen old claims be resuscitated against regulations. So I think some of the dissent's concerns are proving to be correct already.
I think some of this too, David, honestly, how are agencies going to be able to enforce their regulations if no one knows what the regulations are? How are employers going to be able to even try to comply when the regulations are in flux, depending on what circuit you're in, especially in the Fifth?
You know, this strikes me as almost gratuitous. You know, when you have Loper Bright and you have Jerkasy, you have to create some notion that the laws on the books can be relied on. That's how a business runs. That's how an economy runs. That's how most people run their lives. To add this one is almost thumbing your nose at all of the requirements that most people thought a settled government lives by. And they really, really don't like executive agency regulation. And they're letting you know.
Well, Burt, going to the next slide, I think it's very appropriate that we talk about in some detail, what's the impact going to be on the workplace agencies as we know them? So let's go to the next slide and let Burt kick it off. Burt, it's hard to hear you when you're on mute.
At the risk of repeating ourselves, the impact of these ethical decisions, especially this triad of ruling, changes the legal landscape for all businesses. It's going to cause all businesses to look at whether and in what way they can challenge a regulation, or do they have to rely, and in what way do they rely on existing regulations? Chief Justice Roberts insists that the 17,000 cases that were decided under Chevron are secure, but under corner post, we're not sure that means anything if you can raise an objection to a regulation at any time. Agency resources are going to be diverted to defending themselves. They're going to change the way they write regulations. The regulated community has just been told, take a shot. If corner post can do it, maybe you can too. And there's the idea that a regulatory agency is going to have to go back to its statute to figure out how it can craft its presentation to the world and to the courts so that it avoids the notion of Chevron deference and says we establish this on separate grounds. And I should also point out that this is really a kind of the reason we are all talking about this as policy, not law, is that these are political statements and they are being responded to in a political way. The agencies are not taking this kindly. Acting Secretary Sue of the Labor Department said they're not going to back down. In fact, the government just published its regulatory agenda. 2,300 regulations are listed in that agenda. Now, mind you, that's a political statement, not necessarily a going forward plan, but it's the government's response to this. Oh yeah, we're not going to stop doing what we're doing. We are the elected branch of government and we are accountable to the people, and this is what the people think we should be doing. So this is a fight of the separation of powers at the highest possible level of enormous significance.
Well, and you're talking Loper Bright. Let's just talk Jerkasy. You've got more than 24 agencies that impose civil penalties. So how are they going to work through this and figure out whether these civil penalties require that they have to go into federal court? I think, Burt, you were talking about people that are dealing in Ashland. And what are they going to do with the civil penalties that OSHA, EPA, Department of Labor with respect to child labor and so forth use these civil money penalties?
I have a feeling that the amount at issue will have a significant impact on how the case is resolved. Okay. As I say, this may change how cases are settled. There may be a less of a settlement that's not worth challenging, but in some cases, the ones that we've seen where the fines are hundreds of thousands of dollars, Well, that puts someone in mind of saying, maybe I'll roll the dice and insist in this mini trial that this is an instance where this is a remedy at law. I demand a jury and a judge. And that will change the factors that both parties are involved in dealing with. It's a whole new world.
I think
Well, the other thing,
uncertainty is the only certainty.
the other thing though, is to note that the people that are, and we'll talk a little bit about this later, who is challenging. So Jerkasy was a hedge fund manager, and he was, facing $1 million fine. He probably has the resources. We'll talk about Elon Musk and SpaceX or Starbucks or some of these other very large corporations who have the wherewithal to challenge any of these and are being very successful, David.
I think a couple of things. One, the election's going to make a difference on a lot of things, and it makes a difference. If the Biden administration if we have 2.0 of the Biden administration, you're going to see this fought out. The agencies will continue to push their regulatory authority, and they will continue to push a very robust judicial enforcement strategy in order to minimize. They'll run two barrels. And some of this, even though many in the business community think, oh, great, we're going to have regulatory rollback, the uncertainty point is a real one, and you can have different answers in different circuits and so forth. Remember, the agencies, they're going to follow whatever the decision is in a circuit. And they historically have had situations, absent a nationwide injunction, where they have an adverse decision on a regulation in one circuit, but it remains in force for in the other circuits. That can happen. That's likely to happen. On the other hand, if we have the Trump administration 2.0, these recent decisions provide, I think, a strong policy justification for the agencies to start rescinding, modifying, cutting back on regulations, noting that they're doing so in response to and in compliance with the Supreme Court's ruling in Loper Bright and otherwise. And it provides a very strong justification that would probably put them in good light if it were challenged. It's hard to challenge an agency and say you had to affirmatively issue a regulation like this. That's a very uphill challenge as opposed to you overran. So I do think, the after what happens in January going forward will depend a lot. It'll be very different depending on which administration and their approach to regulations. Well, we should focus, I guess, Nita, a little bit on kind of what we've got now, some of these regulations. I'll be happy to just kick off some of the Labor Department stuff. Burt mentioned the regulatory agenda, and our friends at OFCCP, they're in there. I mean, they published the spring agenda last July 5th. Okay. I mean, they didn't even hit the summer solstice. They missed it, but okay. And again, as Burt pointed out, these are, aspirational goals. There's no legally enforceable requirements here, but they said, oh, by the way, we are going to continue to update our 11246 regulations. Well, those will definitely be subject to review. They indicate spring 2025. Again, if the election occurs, we'll never see those regulations. But if the election doesn't occur, we'll see. The ALJ procedures, those are interesting, and we've, I think, touched on that several times now. I just would note that, and I want to share a practice pointer, and this can apply across the board. For those of you that are getting proceedings, for example, a notice to show cause as to why you didn't provide data or documents to OFCCP during an audit, and they're threatening you now to bring you before an ALJ, at a minimum, I think that employers are well counseled to preserve the defense as to whether the ALJ process is licit or not. And I'm talking, you put a footnote in your reply letter objecting, explaining what you did, and noting that you would also object to the ALJ proceedings. I leave to a separate day whether you actually go seek a declaratory judgment or how you proceed litigation-wise. My point is preserve the defense and the argument. Wage hour. Obviously, the FLS regulations have caught a lot of attention, and appropriately so. The overtime regs, the interesting thing is the challenge now says, well, look, Loper Bright affects this. The Labor Department saying, not really. We didn't really rely on that. You don't have to defer. We just looked at the statute, and this is Skidmore deference, and that's sufficient. Skidmore deference is barely deference at all. It's not even clear whether Skidmore remains as an active doctrine. The Chief Justice noted Skidmore, so we think it is still there, but it doesn't get you very far if you're an agency. Having made those arguments as an agency, if I got down to Skidmore deference, it normally meant I was losing when I was at the Labor Department. So, but the overtime reg, the prevailing wage regulations for Davis-Bacon, there's currently a nationwide injunction. It was found that the Labor Department exceeded what the statute authorized. It talks about a construction site. You can't pick up suppliers. You can't pick up truck drivers. They're outside the scope of what the statute authorizes. The overtime and independent, overtime rules, there's a question there with respect to, among other issues, the salary basis and the automatic escalator. If you read the Fair Labor Standards Act, even though the salary test has been part of the regulations for decades, and even though every client that we have wants the salary test, we may disagree what the salary should be, whether it gets adjusted automatically, but we like it for the reasons that Burt highlighted, because it promotes certainty. Either the person is above or below the line. Either you have to get overtime or you don't, subject to job duties. The argument is the FLSA didn't authorize expressly a usage of salary to determine exempt status. Oh gosh, where does that put us? Back to looking at duties. That is a litigation nightmare. And keep in mind, there is no ALJ remedy. We're talking about the Labor Department, or worse yet, private plaintiffs aggressively saying, we don't care what you paid people. Look at the duties. They weren't exempt enough. Those are going to be tough cases, tough to dispose of on pre-hearing motions, summary judgment or otherwise. We've touched on the civil money penalties a moment ago, and those cross the board in multiple programs under the FLSA, OSHA, and other programs. So again, if you're facing CMPs before an ALJ process, you should at a minimum be preserving that defense. And compliance folks on this webinar, you need to confer with your counsel and make an informed decision as to when and how to raise those potential legal defenses. So let's talk a little more. Burt, do you want to pick up on OSHA?
Yeah, OSHA probably is the poster child, along with EPA, for the whole challenge to the administrative state. It's one of the busiest regulators and writes some of the most interesting and challenging regulations. If you've seen an OSHA health standard, it's like reading a major scientific PhD thesis. They're 300-400 pages long, charts and graphs, and many of them have been challenged, and many now will be challenged. And the authority to regulate is usually written there in the various OSH acts and the Clean Water Act, the Clean Air Act that the EPA regulate. But for example, OSHA rulemaking, like the new walk-around standard and the new, which permits third parties, including plaintiffs' lawyers and union representatives, that's already being challenged. OSHA has just published a heat standard, which is being challenged across the country because it reduces the heat standards in such a way that many states claim that's our normal daily temperature. How can we possibly meet that under a regulatory standard? Now, the issue with OSHA, of course, is that the agency will claim that it has a right, it has a duty to base its conclusions on provable scientific evidence that has nothing to do with a judge's authority. And the judge is going to come back and say, wait a minute, I don't care about the science, that's your job. The statute doesn't permit you to do what you claim you have just done. And that is going to be the key issue for OSHA regulation and a lot of environmental regulation going forward. For me, the big unanswered question, David referenced this earlier, is to what degree can OSHA issue regulations under its most general law of delegation? It's called the General Duty Clause. OSHA has a general duty to provide a safe workplace, period. Is that enough upon which to base a particular pointed, specific regulation, and can that constitute an appropriate delegation of authority, and can that authority survive? That's one of the things we're going to be finding out. The impact of Loper Bright and all three of them riffles through the entire Labor Department. The pension, the Employee Benefit Security Agency just issued very controversial ESG, environmental, societal, and governmental regulations. That is to say, can a pension fund take these matters into consideration? It breaches on a stock advisor's fiduciary duty. Without Chevron deference, since this really is a kind of policy statement, although I don't want to get into debating the content of a regulation, the question is whether without Chevron deference, this regulation survives. Obviously, we've already talked about the impact of Jerkasy. Don't need to beat that dead horse, but the DOL relies on administrative processes a lot. And, the nature of the penalty, the nature of the fine, the size of the fine, all of these things are being challenged. For all we know, the whole process may be unconstitutional. Even if it survives, the scope and natures of the kinds of remedies that these agencies are allowed to impose, absent a jury trial, are going to be altered, and that's going to change the balance of power, as it were, in enforcement proceedings throughout the entire Labor Department, and for all employees and for all employers. Next slide.
So EEOC is in a little bit different position than our friends at the Department of Labor, because EEOC goes straight into court. I mean, if they're going to take a case, they file a lawsuit, as we know. However, and rarely do they file regulations. However, as we were talking a little bit earlier, the Pregnant Worker Fairness Act regulations are already under challenge for two. Primarily the challenge was on abortion, that you had to provide an accommodation. There was an Arkansas Federal District Court decision that rejected the challenge by a group of attorney generals, saying they didn't have standing. But they also, in that decision, they relied on Chevron. It's been appealed to the 8th Circuit. We'll see how that goes. There are also a number of other items, as we talked about, how long should an essential function be removed from a pregnant woman's job. There's no specific language in the statute, so EEOC said 40 weeks. That's up for challenge, along with the related medical condition. Generally, they only issue guidance. Their guidance is being strongly challenged around LGBT last year when they issued after Bostock. And nevertheless, they are planning on issuing under the APA in the regulatory agenda. They're going to issue a new pay data collection, assuming that President Biden gets a second term. So that's kind of where the EEOC is at this point.
I just want to add, the guidance on harassment is interesting because although sub-regulatory guidance, and of course, as Nita explained, the EEOC does not have authority to issue regulations under most of the EEO statutes, Title VII, so forth, with some exceptions. PWFA gave them that authority. So historically, they've issued guidance. Well, interestingly, the harassment guidance gets challenged as being effectively an improper rulemaking because it was so detailed. And so the challenges are now, even though it's not a regulation, the challenges are seeking to bring a Loper Bright argument, which is, we can now also get you to independently look at the guidance and not defer to that and vacate that. So, yeah, I think the EEOC is a very interesting situation.
Well, the harassment guidance is being challenged in the same circuit and over the same issues as the guidance that was issued after Bostock over how you treat LGBT bathrooms and so forth. And so I expect that will be yet another injunction.
Well, let's jump to the board. And Burt, you'll need to.
NLRB, probably the most aggressive of all of the agencies under the Biden administration, the most pro-worker and the most aggressive in seeking its remedies. Traditionally, the NLRB's remedies are make whole. That is to say, you back pay, you rehire, you offer the jobs to those who should have, and as a result, it's not affected by Jerkasy. The other thing is that the policy of the board is usually issued through the decisions of the NLRB, and they have a higher degree of deference because the NLRB, the National Labor Relations Board, was established by the NLRA, the National Labor Relations Act, to interpret the act. However, the new remedies that the NLRB is trying to impose as make-whole remedies are being scrutinized. They include such things as not merely back pay, but your rent, your car payment, your additional medical expenses, which have never been interpreted in the past as part of an equitable make-whole remedy. And if you're thinking of if common law fraud has to go back to Henry II, then so do the equitable remedies have to be those that have been used traditionally over the past centuries. I think that the challenge to the joint employer regulation, which is already being challenged, is likely under Loper Bright to find significant hurdles. And I think that the new remedies, such as this expansive make whole remedy that includes things that have not ordinarily been regarded as, let's just say, that changes the contours of what an equitable remedy is, will be closely scrutinized. The General Counsel has also proposed, in the cases being litigated right now, to impose civil money penalties in an administrative hearing in which the board is both judge, jury, and prosecutor. I don't think those those are dead on arrival. The battle that was going on at the board, I think, will be indicative of how judges interpret the kind of breadth and authority that the trilogy of cases we've just seen gives them. And it will be a kind of locus classicus of just where the limits of regulation will be defined.
Well, and just SpaceX, right, one more point. SpaceX and others are challenging the constitutionality of the NLRB or the NLRA and the NLRB as set up. And SpaceX was just able to get a block on the proceeding while that determination is made by the court.
Well, in addition, we have all of these other agencies, not the traditional workforce regulators, but those that have sort of kind of feels like come out of left field a little bit in the last year or two, certainly during the Biden administration. We have the FTC that has spoken up and largely said that the United States will no longer have non-compete agreements. This was upsetting to a number of people in the business community, and as you might expect, pretty broad-based challenges were brought forward. I think it's pretty clear that when you read the statute, going back to the principles that the Chief Justice has walked us through, there's certainly no reference to a non-compete agreement. There's no even reference in the statute that this would be an agency that should be regulating the workplace contracts. And historically, it has not dived into those waters. It's been more of traditional, consumer-related protections, credit card, etc. So, not surprisingly, the FTC regulation has been blocked. Its effective date, there's going to be a further hearing. It's effective September 4, I believe. Yeah, September 4. And so there will be a final disposition, at least by the district court, but before then. I think with a high level of confidence, the non-compete regulation is not going to go forward, period. Second, the SEC. There's a variety of things going on at the SEC. Nita has covered in detail the whole ALJ process that affects so many publicly traded companies, but also the expanded diversity reporting. Burt touched on the ESG relating to pension investments, but there's the companion provision that's actually much broader on ESG reporting. That's again, it's in the 2024 regulatory agenda. SEC is committed. It's going to implement that very broadly. A challenge is, I promise you, will occur. And I think there's a very high likelihood that that type of what we'll call, robust regulatory effort under these new standards will be vacated by the court. All right.
So here we are. We've got about 10 minutes, guys. I love this image. I am, having been an in-house employment lawyer for 21 years, I feel this way having heard you all speak and us speak on these cases. And so let's go to the next one. David, you want to kick us off with what should employers do in the face of all of this?
Sure. So, the Supreme Court dissenters use the tsunami as the analogy, and that's, excuse me, I don't think that's an overstatement. I think that's actually a useful analogy. Whether you agree or disagree, there is a fundamental change, and it may or may not be nice and orderly, probably not. But people that live in areas that are prone to tsunamis can survive tsunamis. How do they survive? There's a lesson for all of us to learn. Those that are mindful that a tsunami can occur, that have their life preserver, that know where the high ground is and how they're going to get to the high ground if necessary. So what do we do in terms of employers? Because on one level, it's like, oh, good, we won't have all these annoying regulations. And then it's like, oh, wait a minute. Now, what are we supposed to do? Do we wait for the agencies to sue us? Does it vary circuit by circuit? We operate in 48 states. What are we doing now? How are we going to be consistent? Point one, you have to comply with the regulations that are on the books today, unless you're spoiling for a fight and want to seek a challenge, and then you can create a case or controversy. Most clients are loath to do that. That's the last thing they want. They don't go spoiling for a fight. They let trade associations do that for them. They try to lay in the weeds, comply, and not get tagged. So be mindful. Even though there's this flurry of litigation, you need to keep in mind where your operations are and what the lay of the land is on every one of the current regulations on the book. Number two, the states. This is the first time we're mentioning the state regulators, but the state regulators, they're not under Chevron. They're not under Loper Bright. This is all based on the Federal Administrative Procedure Act. Now, there may be challenges brought to state regulations that seek to expand or extend that rationale. That hasn't occurred. So it is possible, indeed likely, that there will be obligations under state laws that are now potentially different and even in conflict with the revised federal standards as they get rolled back or pushed forward. That is, as we like to say, a case-by-case determination. But I just want to highlight that we've spent all this time talking about federal regulation. Do not ignore, have your separate screen on what those state regulators are doing and make sure that you've, if you can, reconcile them.
You know, David, I think what we saw was when we did not get an expansion of the Equal Pay Act to include a pay data collection on a federal law, we have a bunch of states that decided, oh, we want pay transparency. We want, collect this data. And you're seeing it sprout up all over the country. I think we'll see some of the same thing in those same states, I might add, of expanding federal what had been the federal ceiling. They're going to jump above that potentially.
I think
the very fact that we're talking about this really highlights one of the issues that's one of the subtexts, and that is the entire system of regulation is under enormous pressure, and the Supreme Court has written decisions that are almost like academic law review articles without contemplating the practical impact of what they have written. And it's almost no federal judge appears to have met a payroll or hired and fired an employee or worked out a budget for next year's business. And that's one of the problems, that we're raising all of these what if issues instead of getting the finality that we hope the Supreme Court provides.
Well, Bert, I think you've got a few more items you wanted to touch on before we
I
close
sure
this
do.
out in the next 2 or 3 minutes.
David talked about one, and that is for multi-jurisdictional employers, they are really at sea. As David pointed out, in many jurisdictions and under many regulations, they go circuit by circuit. The NLRB, for example, does not acquiesce to a ruling of a circuit court. So if you're a multi-jurisdictional employer and you lose a case in the Seventh Circuit, it has no impact for the rest of the remaining 11 circuits. And we're not clear enough about what you're supposed to do, except, as David pointed out, you have to understand the rules you have to live by, jurisdiction by jurisdiction. And that's an enormous challenge for large employers who work in many, many states. As I pointed earlier, the agencies have no intention of taking this line down. They are going to continue to regulate. They are continue to fulfill what they believe is their mission. You can call it the administrative state, or you could call it the functioning bureaucracy. But what's going to happen is, as we've seen from the regulatory agenda, the departments that regulate are going to continue to regulate. You're going to see laws that regulations that are probably longer, hard to believe, and more carefully drafted in light of these decisions, but they're not going away. There's also going to be growing oversight interest in Congress. We've already had letters from the minority ranking member of the Help Committee challenging some of the regulations, demanding that there be some response from the agencies to a congressional letter, which for most agencies means you're going to respond within 2 weeks. So this whole area is just kind of in turmoil. And, what do you do among your planning? I hope you listen to our podcast, the DC Insider, which focuses specifically on what's happening in the federal government and how it affects employers. We'll try to keep you up to date on the latest advances on or whatever actions take place in these various cases that have been remanded and the new ones that are being brought, and they'll be reported on our website. That's part of what employers must now do to plan so that they can try to reduce the level of instability and uncertainty that the court has created.
I want to follow up a little bit on the congressional point, if I could, just a moment. Because Senator, as you referenced, Senator Cassidy, the ranking member on the Senate Help Committee, did send those letters out to the EEOC, the Labor Department, and the Labor Board. You can look it up. He issued a press release. He's got a link to each letter, very detailed. These are like a 6-page set of interrogatories to the agencies. How do you justify what this regulation is? Are you now planning to rescind or modify your regulation? Come forward with how you're going to enforce it. I mean, it is a complete disclosure. And what that is going to lead to is, if the agencies don't start towing the line, if they continue, because at this point there's quite a difference, as Burt explained. Remember, the budgets haven't been approved, all of this. So it is very conceivable that agencies will be collared and precluded from taking actions to enforce regulations that Congress views as being improper. There also is further effort on the other side of the aisle to think about broad brush amendments to statutes, potentially trying to make them retroactive, which is a little hard for me to get my brain around, but okay, retroactive, that would provide sort of a post-Loper Bright authorization. Like, it's okay if you issued these broad regulations. That's really what we wanted you to do. So all branches, the executive branch, the legislative branch, and of course the judicial branch, are extremely active in this. And I view employers, we're just sort of that little pinball kind of in the middle, trying to move along. But there's a lot of activity on all fronts.
So guys, we only have a minute or two. So do we want to have, David, do you want to have a 1 second or two of
I'll just
thought?
real quick. Don't forget the defense. Don't forget to preserve your defenses. Little footnote, little statement when you're responding to agency investigations.
Burt?
Mine is more a kind of summary, excuse me, of where we've been. To remember, there is no deference now to the agencies. There does not appear to be a statute of limitations. And it's very, very difficult for a business to plan for tomorrow. And the only certainty appears to be a lack of certainty. So I urge everyone to pick up on our advice to plan for what you must comply with and what you should oppose.
Agreed, 100%. So Valerie, you want to take us out now with this?
Yes,
Thanks,
we
Nita.
would like to thank you for joining us. If you have further questions, please email us at info@FortneyScott.com. And as mentioned, please listen and subscribe to FortneyScott's DC Insider Employer Update podcast, which you can find on FortneyScott.com or anywhere you listen to your favorite podcasts. Thanks.